I'll be speaking today on an area of international law that probably most of you don't know anything about or may not even know exists, which is international drug control law. International drug control law dates back over 100 years in multilateral treaty form, and in the modern era, it has wide-ranging and direct impact on the domestic criminal law and health policy of almost every country in the world. But despite those two facts, it's an area which has received surprisingly little academic attention and very little scholarship. So I'm going to be talking today on the topic of the fifth stage of drug control, international law, dynamic interpretation, and human rights. I'll be looking at what my thesis addresses, which is the interplay between international drug control law and international human rights law, and strategies for resolving conflicts between the regimes. The topic, or the title of my presentation, is drawn from the work of Professor Quincy Wright. Professor Wright was one of the major figures in international law and international relations in the first half of the 20th century. And he wrote an article for the 1924 edition of the American Journal on International Law, in which he described the three stages of drug control, as he called them, contemporary to that period. Wright's first stage was the drug control of the 18th and 19th century. This was a period of time when opium was a major commodity of international trade. The British East India Company had a monopoly trade in opium during that time. We had two opium wars fought between Britain and China in the mid-19th century. And in terms of legal development, drug control or drug suppression was really seen primarily as a national matter or at best a bilateral issue. Wright's second stage of drug control begins in 1909 with the meeting of the first International Opium Commission in Shanghai. This was a meeting of 13 states, and it was really the very first multilateral meeting on drug control. They produced quite a long report on the opium trade and a number of recommendations, which in 1911, at the second meeting of the International Opium Commission at The Hague, these recommendations were codified into the very first international drug control treaty, which was the 1912 Opium Convention. Professor Wright's third stage of drug control, which was the period contemporaneous with the time he was writing, begins in 1920 with the foundation of the League of Nations. Now, one of the critiques that member states had of the 1912 Opium Convention was that it didn't establish any kind of machinery or mechanisms or bodies through which to advance the obligations in the treaty. So in the third stage of drug control, we see the League of Nations as a body of the international community as a whole, taking a more direct interest in international drug control. We see the creation of new supervisory bodies, new technical bodies, and in the years after Wright's article was published, we see the adoption of three major and two lesser drug control conventions. So using Wright's framework, my work focuses on what I call the fourth stage of drug control, which is the drug control regime post-1946 under the auspices of the United Nations. In terms of legal development, we have three major international conventions that have been ratified during the United Nations period. The first in 1961, the Single Convention on Narcotic Drugs. This is essentially a treaty which pulls in all the previous existing instruments into a modernized single treaty. Addresses primarily the control of plant-based drugs, so opium, coca, and cannabis and their derivatives. We have a second convention in 1971 on psychotropic substances, which extends controls essentially to synthetically produced drugs, laboratory-produced drugs, hallucinogens, amphetamines, barbiturates. And in 1988, the Convention Against Illicit Trafficking, which is essentially a very major convention that looks at harsh penal provisions related to drug control. Now, my premise is that there are at least three factors that separate the fourth stage of drug control, the UN periods, from its predecessors. The first is the increasing use of penal law as a tool for drug suppression, to the degree which I would suggest in the modern era, penalization and criminalization really has almost come to the fore as the main tool for drug suppression. The second factor is the near universal ratification of the core instruments. Each of those treaties has over 180 states parties. So what that means is essentially this harsh penal approach to drugs becomes domestic law in almost every country of the world. And then the third factor separating it from its predecessors is that this body of international drug control law evolves alongside of and in parallel to an increasingly robust system of international human rights law, beginning in 1948 with the Universal Declaration, and of course moving into the core human rights treaties from the 1970s onwards. And what we see increasingly then in these two parallel regimes is an increasing observance of human rights violations at domestic level being linked to efforts to enforce drug control. Essentially a situation where state attempts to fulfill drug control obligations end up violating human rights obligations. And we can see that all over the world in many different examples. We have over 1,000 people executed each year for drug-related offenses. We have several million people in the world denied access to HIV prevention measures simply because they're active drug users. We have over 500,000 people in arbitrary detention, illegal detention, for the purposes supposedly of drug treatment. Certainly in parts of South America, we have military operations spraying pesticides from the air, allegedly to kill coca plantations, but it has significant health impacts on communities. It's been criticized by the Committee on the Rights of the Child, the Special Rapporteur on the Right to Health. And also in the Andean region of Latin America, we see the prohibition of traditional uses of coca directly undermining indigenous rights, communities that have harvested coca for traditional uses for millennia. So we see human rights abuses linked to drug policy really in every corner of the world. But despite this fact, there's been very little engagement between the drug control regime and the human rights regime. The drug people don't tend to talk about human rights, and the human rights people don't tend to talk about drugs. And this situation raises questions around conflict of laws, what we call now the fragmentation of international law, conflicts between regimes and how those two regimes engage with each other. Traditionally, when we talk about engagement between legal regimes, we talk about laws or treaties engaging in one of two ways, complementarities or conflicts. Complementarities are essentially when two obligations in parallel regimes reinforce one another. They have sort of the same normative content, they reinforce the obligations. One might have more detail that builds upon the other, but they're essentially complementary, sometimes called accumulating norms. Or norms can be in conflict. And the typical traditional approach to conflict is a situation where fulfilling the obligations of one treaty norm necessarily breaches another. So it's a situation where it's impossible for a state to be simultaneously compliant with both obligations. But within drug control, we see what we call a third area, and my colleague Damon Barrett, who I do a lot of work with, calls this tensions. This is situations where international drug control law being implemented at domestic level creates human rights violations. So it's not necessarily a conflict of laws in the sense it's not being drawn directly from the drug control obligation itself, but it's more about how the state interprets and enacts that particular obligation in domestic law. And this is really the source of the vast majority of human rights abuses we see linked to drug control. So the question that I've looked at is how should international drug control law be interpreted in situations where it engages international human rights law? How do we resolve those conflicts and tensions between the regimes? And I think a central way to begin to look at an interpretive framework is looking at the question of object and purpose of treaties. There's been a lot written on object and purpose. When we try to come up with an object and purpose of a treaty or of an international legal regime, we have a number of sources we can refer to: the treaty texts, the preambles, to some degree the drafting history, to some degree parallel instruments. My approach to object and purpose looks at the term as a single term, but actually reflecting two different sort of levels of content. And this is very much drawn from some of the French approach to some of the international legal questions, which looks at object and purpose as kind of two separate concepts. The first is what I call a utilitarian object and purpose, which is essentially the normative content of the treaty. What is the actual legal framework that the obligations create? And what is the objective of creating that legal framework? But then beyond that, a lot of scholars write about also, on top of the utilitarian object and purpose, we have the telos of the regime, or what are the ultimate aims or goals that that framework of law hopes to contribute to. A really good example of this can be seen in the 2013 Arms Trade Treaty, which specifically separates object and purpose at the beginning of the treaty. It says specifically that the objective of the treaty, of the legal framework, is to provide controls on conventional weapons and stop them from leaking into illicit markets. But the purpose of creating that legal framework is to contribute to international and regional peace and security. So very clear, you have the legal framework that has sort of a more utilitarian objective, and then that objective is supposed to contribute to a grander sort of international product or a grander state of affairs. And I argue that this approach fits very well within conceptions or conceptualizations of international drug control law. If we want to look at utilitarian object and purpose, I think from a review of the relevant sources, it's very clear that the utilitarian object and purpose is to control the manufacture, production, use, importing and exporting of controlled substances to medical and scientific purposes. This is something we see very clearly throughout the major international instruments. This is from the 1961 Drug Convention. The top piece is from the preamble, limiting drugs to medical and scientific use. Article 4, which outlines the general obligations of the treaty itself, says in Clause C that limiting exclusively to medical and scientific purposes the production, use, and manufacture of drugs is the core objective of the instrument. We see similar language in the 71 Convention and the 88 Convention. More importantly, we see it in its predecessor instruments. We see it in the 1912 International Opium Convention, the 1925 Opium Convention. So this idea of limiting drugs to medical and scientific purposes is very well reflected in the modern instruments and the drafting histories, but it also comes very clearly from the previous instruments from the League of Nations era and earlier. This, I argue, contributes to the broader overarching aim or the telos of the regime, which is to promote the health and welfare of humankind. And again, we get this very clearly from the core instruments. The preambles of both the 1961 and 1971 conventions start with the statement that the parties are concerned with the health and welfare of mankind. This is the opening statement of both treaties, and I would argue is actually the framework in which the treaties are then supposed to be read. And again, this is not a new concept. I mean, it might be surprising to a modern audience, but if you go back to the earlier conventions, even going back to the 1909 Opium Commission, drug control and suppression has been described in humanitarian terms, as a humanitarian endeavor, as a humanitarian effort. We might think that's a bit odd in terms of some of the war on drugs kind of activities we see today, but again, when we go back into the historical instruments and the drafting histories, the debates between states, the idea that drug control is a humanitarian endeavor comes up time and time again. So again, I argue this fits very nicely where the medical and scientific purposes is a legal framework upon which to help promote the health and welfare of humankind. So when we get in then to questions of interpretation between the two regimes of human rights and drug control, I argue in favor of a dynamic interpretive approach. Now, obviously, dynamic interpretation is very well established in international human rights law, in the jurisprudence of the European Court, in the Inter-American Court, the Human Rights Committee at the UN. We see human rights is very much comfortable with the idea that treaties have a dynamic interpretation. But if you look outside of human rights, you do find examples in other treaty regimes where a dynamic approach has been taken. We see examples in the European Court of Justice. We see examples in the appellate body of the World Trade Organization. So this would indicate then that it's not outrageous to look beyond human rights treaties to try to impose or use a dynamic interpretive approach. I specifically look at the jurisprudence of the International Court of Justice, which I think is particularly useful in this regard. The International Court of Justice uses a dynamic interpretive approach, and in fact, in its own jurisprudence, has laid out specific criteria for when a treaty or treaty provision can and should be looked at in a dynamic fashion. Helmerson describes or sort of summarizes the two positions as being value-driven and non-value-driven in terms of the text of the treaty. What that means in terms of value-driven is when the language itself expresses some kind of social value, or in terms of what the court says, where it's acceptable to think that the drafters would have presumed, based upon the language itself, that it would have been a changing approach based upon different generations or different societies looking at it. Again, in the advisory opinion on Namibia, where this jurisprudence was put forward, the court was looking at a specific provision of the Covenant of the League of Nations. And that specific provision had terms in it such as the well-being and development of peoples, a sacred trust, the strenuous conditions of the modern world. And the court found that these terms were by definition value-laden, and because of that were by definition evolutionary, because it could be expected that different people in different generations would read different kinds of expectations into those provisions. But the court doesn't limit dynamic interpretation just to value-based language. They also have specific criteria where obligations don't express value-based. And this is, again, what Helmerson refers to as non-value-driven language. The court lays down two general rules when you have a provision that's not necessarily reflecting social values, but could be read in a dynamic or an evolutive fashion. One is the use of generic terms in the provision itself, or terms that refer to an entire class of activity. And the second is where the treaty itself has been enforced for a long period of time or is of a continuing duration. Now, I argue that in terms of international drug control law, the treaties themselves and the regime actually fit very nicely into both of these categories. Again, we took a look at the teleological approach, the health and welfare of humankind, very much a value-driven sense of language. Health and welfare, in fact, as a term, is very, very similar, almost identical in some ways to the language the International Court of Justice we're looking at in the Namibia case. But beyond that, we can look at the utilitarian, medical, and scientific purposes. Again, that falls very comfortably, I think, into the non-value-driven approach. Medical and scientific purposes is a generic term referring to a class of activities. I would argue it's a term that's by definition evolutionary, in the sense that medical and scientific knowledge by its very basis advances and changes over time. And of course, the drug control treaties themselves are of a continuing basis, and in fact, at this point in time, have been, even in the UN era, in force for more than 50 years. So to conclude, I guess this takes me to my final argument, was moving towards what I call a fifth stage of drug control. So moving beyond the fourth stage, where drug control and human rights exist in different silos, where the drug control regime itself is manifest with human rights abuses around the world. I try to look at a dynamic interpretive approach, but a dynamic interpretive approach that's human rights based. And what I mean by that is that in interpreting international drug control law, the interpretive approach has to be one that at minimum is compliant with human rights, and at best actually advances core human rights principles. And I say that again, getting back to this question of object and purpose. When we look at, for example, some of the key writings or the key thinking on treaty interpretation, so the International Law Commission, the Fragmentation Report, if we look at the Vienna Convention on the Law of Treaties in terms of its approach to treaty interpretation, we see very clearly that proper interpretation has to take the instrument in the context of the normative environment in which it sits. And I would argue that, in fact, the normative environment, when we look at the object and purpose of the drug control treaties, is very much a human rights-based normative environment. If we look at questions of medical and scientific purposes, I would argue that that very clearly engages right to health, Article 12 of the Covenant on Economic, Social, and Cultural Rights. I think it engages things such as Article 27 of the Universal Declaration, the right to benefit from scientific progress, which is also reflected in the Covenant on Economic, Social, and Cultural Rights. So this idea of medical and scientific uses or purposes, I think, very much sits within a human rights ethos. And more specifically, the telos of the regime promote the health and welfare of humankind. I mean, health and welfare are, by definition, human rights concepts. They're not drug control concepts. And if the purpose of the treaties is actually to try to promote the health and welfare of humankind, I would argue that that's not something that can be achieved through drug control alone. Drug control may contribute to that if it's done well. But more importantly, it's not even something you can measure in drug control terms. If you're looking at indicators to measure advancement of health and welfare, you're looking at human rights-based indicators. So I sort of conclude by looking at what a fifth stage of drug control might look like in terms of interpretive bodies, looking at some examples from national jurisprudence or some international bodies where I think we can, in a small way, begin to see examples of this dynamic human rights-based interpretive approach at play. And I'd be happy to talk about some of those if we have time. So thank you very much.